Welcome back to the High Court Report. We come to you this Tuesday, November 25th, just 2 days from Thanksgiving. I hope everyone travels safely to their destinations. In this episode, you'll hear highlights from the Trump Tariff Cases oral argument. I found this case fascinating on so many levels. Pay special attention to the questions from Chief Justice Roberts and Justice Barrett because they're probably the swing votes in this case. In my view, their questions foreshadowed how they'll vote. What's your take on how they'll decide the case? I included chapters so you can quickly skip forward and backward if any particular areas of this case interest you. You can find us on Apple Podcasts, Spotify, YouTube, and wherever you get your podcasts. Just search the High Court Report. And remember, if you liked the episode, please follow, rate, subscribe, and share. Let's dive in.
Would you spend a few minutes on why exactly the major question doctrine doesn't apply to the president in this case?
Yes, Justice Thomas, and I maybe make 2 or 3 points on that front. First of all, though the major questions doctrine may apply to the president in other contexts, specifically in the foreign affairs context where he has his own inherent Article II authority, it's a particularly poor fit to apply the major questions doctrine, and that's for at least 2 reasons. First of all, just as a matter of kind of common sense interpretation, one would expect Congress to confer major powers on the president to address major, sort of international crises, so to speak, in foreign arising emergencies, that's just sort of a natural common sense thing you expect Congress to do. And in fact, Justice Jackson in his Youngstown opinion addressed this very situation in pages 652 and 653 when he says, this is the system within this is the procedure within our constitutional system that we have developed to strike the balance. What Dames and Moore described as the never-ending tension between the need for the executive to have robust powers to address emergencies and to subject it to checks and balances. What our constitutional system has devised to address that particular problem, that never-ending tension, is the system where Congress confers broad and necessary powers in advance and subjects them to ongoing political oversight, which is exactly what you see in IEPA. So that's one reason. One reason is just as a matter of common sense interpretation, you would expect Congress to grant major powers to the president who has his own broad range of major authority, inherent Article II authority in this context. And that is buttressed by the second point.
Can I interrupt you, General, there? And I know that you have a second question, and I want to let you get to that. But just on that first reason, it seemed to depend a lot on the president's inherent Article II powers. And I'm wondering which powers you're speaking of there. Because tariffs, one would naturally think, are the power to impose taxes, the power to regulate foreign commerce. These are not things that are thought of as Article II powers. They are quintessential Article I powers. So what kind of Article II powers are you relying on when you gave the answer about major questions to Justice Thomas?
I would refer to what the court said, for example, in Egan, Department of Navy against Egan. That's a generally accepted view that the president has broad authority in the foreign affairs realm. Now, there's been debates about exactly how far it goes and how to draw the boundary between the president and Congress. But Egan, Garamendi, other cases, Curtis Wright, the court has recognized the president has broad inherent authority to address foreign situations, foreign affairs, foreign policy, including foreign arising emergencies.
You've already mentioned Dames and Moore three times, which surprises me a little because the court in Dames and Moore went out of its way to say that it was issuing a very narrow decision that pretty much expected to apply only in this case. Just a few quotes. It said, decisions in this area have been rare, episodic, and afford little precedential value for subsequent cases. Again, we lay down no general guidelines covering other situations not involved here and confine the opinion only to the very questions necessary to decision of this case. And it ended the opinion. It said, finally, we re-emphasize the narrowness of our decision. Now, this at issue in Dames and Moore was a different provision of IEPA, not at issue here, and certainly did not concern tariffs. So I don't quite understand how you can get as much out of Dames and Moore as you're trying to get.
Maybe I could put it this way. You don't dispute that Dames and Moore is, as you state, a narrow opinion. However, it address certain principles that we think are equally applicable here. For example, the interpretive principle. Dames and Moore held, and again, it was the power to nullify and void, not the power to regulate, but it's in the very same sentence, in the very same statute, and the court quoted the First Circuit opinion and said, look, this is sweeping and unqualified language, which it didn't disagree with. And then it said, this particular provision where Congress has given these broad verbs, I mean, regulate is a capacious verb, admittedly, so are nullify, so are void, so are, frankly, all the other verbs there in the language in IEPA.
I'm sorry. You're talking so quickly.
Sorry.
President Nixon did not rely on TWIA initially to impose the tariffs. Is that correct? I understood that was just a litigating position that he took once it was challenged. That was not his initial.
I wouldn't put it that way because he has a broad invocation. I'm invoking all range of statutes, something like that, in Proclamation 4074. And I think the understanding is he didn't want to kind of spook our allies by invoking the Trading with the Enemies Act, by specifically invoking it. But in litigation, it was defended on that ground. So the Department of Justice defended it as an exercise of TWIA and did so successfully.
What's the significance of the Nixon example and precedent here? Because I think figuring that out is real important to deciding this case correctly. So,
well, there's one obvious, very powerful takeaway from it, which is that this very two-word phrase, regulate importation, that we say it carries with it the authority to tariff, impose regulatory tariffs at the border, forward-facing tariffs at the border, and we say that's a core application of the phrase regulate importation, had been interpreted 2 years before Congress reenacted that language in IEPA, had been interpreted to carry with it the authority to impose tariffs. So this court said in Algonquin, for example, with respect to President Nixon's
just back on the Nixon, what was the scope of the Nixon tariffs?
10%, he imposed a 10% tariff kind of across the board to all our major trading partners to address a balance of payments deficit, where he was trying to bring all the major industrial nations to the negotiating table, which he successfully did, for the imposition of the tariffs, and they negotiated the Smithsonian Agreement in about 5 months, after which he lifted the tariff. So the tariff there was used as here, in part as leverage to get our trading partners to the negotiating table, and it was subsequently upheld by the Federal Circuit, the CCPA, its Federal Circuit's predecessor that had exclusive jurisdiction over that question, to include the power to tariff. And then 2 years later, Congress took that same phrase and reenacted it in IEPA after carefully studying the problem of presidential emergency powers and being deeply concerned about, excessive or abusive exercise of that power.
Sauer, can I just ask you a question? Can you point to any other place in the code or any other time in history where that phrase, together, regulate importation, has been used to confer tariff-imposing authority?
Well, as to regulate importation, that was held in TWIA. So obviously, and that's
okay. So an intermediate appellate court held it in TWIA, but you just told Justice Kavanaugh that wasn't your lead argument. That your lead argument was this long history of the phrase regulate importation being understood to include tariff authority. So my question is, has there ever been another instance in which a statute has used that language to confer the power?
Well,
putting aside Yoshida.
I mean, obviously, other statutory example is just imports. The cases we rely on are cases where, for example, in Gibbons, it's Ogden and Justice Story's
But that just shows the word can be used that way. None of those cases talked about it as conferring tariff authority. I understood you to be citing McGoldrick and Gibbons in those cases just to show that it's possible to say that regulating commerce includes the power to tariff.
Could you just answer the Justice's question?
Can you identify any statute that used that phrase to confer tariff?
Yeah, the only two statutes I can identify now are TWIA, as interpreted in Yoshida, and then closely related, not regulate importation, but adjust imports in Section 232.
Well, I think adjust imports is differently. So the answer is the contested application in TWIA and then now in IEPA.
And then, of course, I mean, there's a sort of direct line there.
Yeah, I understand that, but
yes.
okay.
But then more fundamentally, we rely on the historical sources to show there's this long historical pedigree of broad delegations of the foreign commerce power, not the power to tax that we're not asserting here, delegations of the foreign commerce power to the president, going back to Gibbons against Ogden, all the way through McGoldrick and Board of Trustees, where this court and founding era sources say the power to, in other words, the power to tariff is kind of this natural, as everyone knows, that includes.
Just ask you one other question about the plain text, General Sauer. So you've referred to the other verbs in IEPA as capacious. Would you really describe them as capacious? Because to me, things like nullify and void have definite meanings. I agree with you that regulate is a broader term, but those words I think are powerful. They pack a punch, but I wouldn't describe them as capacious in the sense that they have a wide range of meaning. So can you describe what you mean by capacious?
Let me put it this way. You look at all 9 verbs together, and you're looking at a spectrum of powers from the most sort of negative, nullify, block, prohibit, void, to the most affirmative, direct, compel, and then also powers in between that are more intermediate, regulate, investigate, and so forth. So the natural common sense inference from that grammatical structure is the intention of Congress to sort of cover the waterfront.
Well,
to grant the power
possible, except Congress did take out a whole bunch of verbs. It took out confiscate, vest, hold, use, administer, liquidate, sell, which were in the prior statute. And crucially, what it doesn't have here is anything that refers to raising revenue. So it has a lot of verbs. It has a lot of actions that can be taken under this statute. It just doesn't have the one you want.
Well, I would say the notion that all these other verbs are sort of not revenue-raising like block and prohibit, I think that argument is unconvincing for 2 reasons. One, of course, is that we're not saying it confers a revenue-raising power. We're saying it confers a regulatory power, and that's a crucial distinction. But also—
Yes, but if I can just stop you there, regulatory power, I mean, yes, it says regulate, but I'll broaden out Justice Barrett's question. Is there any place that you can find in the entire code where regulate, used just as regulate, includes taxing power?
We don't assert that. We say it includes tariffing power when it's combined with importation, and that's just the most natural.
Some time ago, you dismissed the applicability of the major questions doctrine, and I want you to explain that a little bit more. I mean, it seems that it might be directly applicable. You have a claim source, an IEPA, that had never before been used to justify tariffs. No one has argued that it does until this particular case. Congress uses tariffs in other provisions, but not here. And yet, and correct me on this if I'm not right about it, the justification is being used for a power to impose tariffs on any product from any country in any amount for any length of time. That seems like, I'm not suggesting it's not there, but it does seem like that's major authority, and the basis for the claim seems to be a misfit. So why doesn't it apply again?
Well, we agree that it's a major power, but it's in the context of a statute that is explicitly conferring major powers, that the point of your power is to address major questions, which are emergencies. So it would be unusual to say, look at the statute and say, we're not going to find a major power here.
Well, but the exercise of the power is to impose tariffs, right? And the statute doesn't use the word tariffs.
But it uses the word regulate importation. And historically, a core central application of that, a big piece of that, has always been to tariff. If you had asked the founders, how do you regulate imports? They would say, of course, we tariff. That's what we do. So it would be very unusual to say, we're giving you power to regulate importation, and say, but you cannot impose regulatory tariffs. That'd be almost a contradiction. And all the historical sources we cite in our brief, relate to that particular historical pedigree. And as I was referring to earlier, there's a specific pedigree of regulated importation here in the specific context of the Presidents Polk and Lincoln and President McKinley asserting the authority to impose tariffs in wartime that was then codified in TWIA and then recodified for peacetime in TWIA in 1933 and then carried over into IEPA. So there's that as well. But more importantly, if you look at the sort of triggering conditions that members of this court have identified for the major questions doctrine, there's a series of them, and we think they really all of them don't apply here. For example, the notion that the power is unheralded. You referred to the fact that IEPA has never been asserted to invoke tariffs, but of course, the immediately predecessor statute, the tariffs that President Nixon imposed on that were upheld under this very language. So this, I would say this is, and it was recodified in IEPA 2 years later. So this is kind of the opposite of unheralded power. It's also heralded because there's this long-standing delegation, a tradition of very broad delegations of the foreign commerce power going back to the founding, going back to—
Well, yeah, foreign commerce part, but I mean, and I think this is a question for the other side as well. It's two-facing. Yes, of course, tariffs in dealings with foreign powers, but the vehicle is imposition of taxes on Americans, and that has always been the core power of Congress. So to have the president's foreign affairs power trump that basic power for Congress seems to me to kind of at least neutralize between the two powers, the executive power and the legislative power.
Let me say two things in response to that. First, the notion that the taxes are all borne by Americans and are not borne by foreign producers whose goods are imported is empirically, there's no basis for that in the record. It's actually a mix.
Well, who pays the tariffs? If a tariff is imposed on automobiles, who pays them?
Typically there'd be regardless of who the importer of record is, there'd be a contract that would go along the sort of line of transfer that would allocate the tariff, and there'd be different. Sometimes the foreign producer would pay them. Sometimes the importer would bear the cost. The importer could be an American, could be a foreign company. A lot of times it's a wholly owned American subsidiary of a foreign corporation. So it gets allocated. The empirical estimates range from like 30% to 80% of like how much is borne by American
it's
citizens.
been suggested that the tariffs are responsible for significant reduction in our deficit. I would say that's raising revenue domestically.
There certainly is an incidental and collateral effect of the tariffs that they do raise revenue, but it's very important that they are regulatory tariffs, not revenue-raising tariffs. And the way you can see this, I think, if you look at this policy is by far the most effective if nobody ever pays the tariffs. And I say two policies, right? So if you look at the trade deficit emergency, if nobody ever pays the tariffs and instead Americans direct their consumption towards American producers and stimulate the rebuilding of our hollowed-out manufacturing base, then the policy is by far the most effective. So a tariff...
General, the verbs that are in the statute are actually doing something. I mean, they're in the statute for a reason, and as I understand it, Congress actually explained to us in its Senate report and House report when it enacted the 1941 amendments to TWIA what it was doing. It said that what we are doing is authorizing the president, in the Senate report, quote, to control or freeze property transactions where a foreign interest is involved. There's similar language about controlling, freezing control in the House report. So I appreciate that generally you can look at these words and you can imagine that they mean certain things, but here we have evidence that Congress was actually trying to do a particular thing with respect to the authority that it was presenting to the president, and that thing was not raising revenue.
I think that the powers that Congress was conferring on the president are best understood through the plain text of the statutes, which includes regulating importation.
No, I know, but some of us care about the legislative history. And so the plain text of the statute has certain verbs in it. It also has regulate commerce, as you say. And when I look at the legislative history, it appears as though Congress was trying to give the president the authority to, quote, control or freeze property transactions where a foreign interest is involved. And in the TWIA context, that makes perfect sense because we're talking about a wartime dynamic. And what is happening is the president needs the authority to prevent trading with the enemy in the midst of a war. And that seems to be the focus of this statute. So I guess I'm concerned about just sort of taking a particular word here and there and saying that the general view of it might include raising revenue when, in fact, it looks as though the aim of this was really to give the president a certain kind of authority to freeze the assets of the enemy.
And let me say two things in response to that. First, as the notion that this is a revenue-raising tactic or power, it is not. We are asserting a regulatory power. It's a delegation of the power to regulate foreign commerce. The way to control imports traditionally has been to tariff them. They say, well, you can impose quotas. Well, quotas are essentially economically equivalent to tariffs. So the question is, why would you be able to quota under-regulate but not tariff under-regulate when the tariffs are themselves regulatory? And let me turn back to the question the response I was giving.
The court of the CCPA said things in Yoshida that are helpful to your position, but it also said some other things. It said that future surcharges, quote, must of course comply with Section 122 of the Trade Act of 1974. And it said that the Trading with the Enemy Act did not authorize the president to, quote, fix rates of duty at will without regard to statutory rates prescribed by Congress. So do you think that Congress, to the extent Congress had that decision in mind and relied on it, do you think it also relied on those statements in the opinion?
Not in the same way, because those statements are read into other provisions of TWIA that Congress did not enact in a NEPA. They may still be there in TWIA, but those are limitations that it wouldn't make sense to do.
What would prohibit Congress from just abdicating all responsibility to regulate foreign commerce, for that matter, declare war, to the president?
We don't contend that he could do that. If it did,
Why not?
Well, because we're dealing with a statute, again, that has a whole series
I'm not
of
asking about the
disciplines and
statute.
limitations.
General, I'm not asking about the statute. I'm asking for your theory of the Constitution and why the major questions in non-delegation, what bite it would have in that case.
I would say by then you would move from the area where there's enormous deference to the president, actually both the political branches, where here there's inherent authority, and piled on top of that there's a broad delegation.
You're saying there's inherent authority in foreign affairs, all foreign affairs. So regulate commerce, duties, and tariffs and war. It's inherent authority all the way down, you say. Fine. Congress decides tomorrow, well, we're tired of this legislating business. We're just going to hand it all off to the president. What would stop Congress from doing that?
That would be different than a situation where there are metes and bounds, so to speak. It would be a wholesale application.
You say we are not here to judge metes and bounds when the foreign affairs. That's what I'm struggling with. You'd have to have some test. And if it isn't the intelligible principle test or something more with more bite than that, you're saying it's something less. Well, what is that less?
I think what the court has said in its opinions is just that it applies with much less force, more limited application in this context. So perhaps the right to approach it is a very, very deferential application of the intelligible principle test, that sort of wholesale abdication of.
All right, so now you're admitting that there is some non-delegation principle at play here, and therefore major questions as well. Is that right?
Very limited, very, very deferential. Okay. Limited is what, and again, the phrase that Justice Jackson uses, it just does not apply. At least
I know, but that's where you started off, and now you've retreated from that, as I understand it.
Well, I think we would, as our frontline position, assert the stronger position, but if the court doesn't accept it, then if there is a highly deferential.
Can you give me a reason to accept it, though? That's what I'm struggling and waiting for. What's the reason to accept the notion that Congress can hand off the power to declare war to the president?
Well, we don't contend that. Again, that would
well,
be.
Well, you do. You say it's unreviewable. There's no manageable standard, nothing to be done. And now you're – I think you – tell me if I'm wrong. You've backed off that position.
Maybe that's fair to say.
Okay. All right. What would prohibit Congress from just abdicating all responsibility to regulate foreign commerce, for that matter, declare war, to the president?
We don't contend that he could do that. If it did,
why not?
Well, because we're dealing with a statute, again, that has a whole series
I'm not
of
asking about the
disciplines and
statute.
limitations.
General, I'm not asking about the statute. I'm asking for your theory of the Constitution and why the major questions in non-delegation, what bite it would have in that case.
Yes. I would say by then you would move from the area where there's enormous deference to the president, actually both the political branches, where here there's inherent authority, and piled on top of that there's a broad delegation.
You're saying there's inherent authority in foreign affairs, all foreign affairs. So regulate commerce, duties, and tariffs and war. It's inherent authority all the way down, you say. Fine. Congress decides tomorrow, well, we're tired of this legislating business. We're just going to hand it all off to the president. What would stop Congress from doing that?
That would be different than a situation where there are metes and bounds, so to speak. It would be a wholesale application.
You say we are not here to judge metes and bounds when the foreign affairs. That's what I'm struggling with. You'd have to have some test. And if it isn't the intelligible principle test or something more with more bite than that, you're saying it's something less. Well, what is that less?
I think what the court has said in its opinions is just that it applies with much less force, more limited application in this context. So perhaps the right to approach it is a very, very deferential application of the intelligible principle test, that sort of wholesale abdication of.
All right, so now you're admitting that there is some non-delegation principle at play here, and therefore major questions as well. Is that right?
Very limited, very, very deferential.
Reason to accept it, though. That's what I'm struggling and waiting for. What's the reason to accept the notion that Congress can hand off the power to declare war to the president?
Well, we don't contend that. Again, that would
well,
be.
You do. You say it's unreviewable. There's no manageable standard, nothing to be done. And now you're – I think you – tell me if I'm wrong. You've backed off that position.
Maybe that's fair to say.
Okay.
Because
all right.
That would be,
Thank
I think,
you.
an abdication. That would really be an abdication, not a delegation.
I'm delighted to hear that, you know. Okay. All right. General, if I can cut through those words, I think you're saying that, no, the president doesn't have inherent authority over tariffs in peacetime.
Absolutely. That is,
Okay.
we do not assert that. We say that Congress can delegate that to him, and when Congress does so, as it does when it uses the phrase regulate importation.
I follow
I
all of that.
I agree.
Okay. You emphasize that Congress can always take back its powers. You mentioned that a couple of times. But don't we have a serious retrieval problem here? Because once Congress delegates by a bare majority and the president signs it, and of course every president will sign a law that gives him more authority, Congress can't take that back without a supermajority. And even that, it's going to be veto-proof. What president's ever going to give that power back? Pretty rare president. So how should that inform our view of delegations and major questions?
I would look at the balance that Congress struck, because what Congress did initially, it had a two-house legislative veto.
And we struck that down.
And then Congress went back to the statute and amended it.
Yeah.
It took out the legislative veto and left in the joint resolution, but still left the president with all those powers.
That's what Congress did?
Yes.
Fair enough. As a practical matter, in the real world, it can never get that power back.
I disagree, because in January 2023, Congress voted to terminate one of the biggest IEPA emergencies ever, the COVID emergency, and the president went along with that. So what the statute reflects is there's going to be the ability for a sort of political consensus against a declared emergency.
Well, what happens when the president simply vetoes legislation to try to take these powers back?
Well, he has the authority to veto legislation to terminate a national emergency, for example. I mean, he retains the powers in the background because IEPA is still on the books. But if he declares an emergency and Congress doesn't like it and passes a joint resolution, yes, he can absolutely veto that.
Yeah, Congress, as a practical matter, can't get this power back once it's handed it over to the president. It's a one-way ratchet toward the gradual but continual accretion of power in the executive branch and away from the people's elected representatives.
I disagree with that, and the recent historical counterexample of Congress's termination of the COVID emergency demonstrates that the political oversight.
Figuring out what regulate importation means is obviously central here, and for major question purposes, I think the way we think about that kind of question is, does the specific authority, power, major power, now asserted pursuant to that general statutory authorization, was that the kind of power that would have been understood by people, by Congress at the time the general statute was passed, as distinct from being a novel kind of use of that general authority to do something different? Unheralded is the word in our cases. Okay. One problem you have is that presidents since IEPA have not done this. Your primary answer, or one of your many answers to that, is the Nixon example. And that's a good example for you, because Nixon relied on regulate importation to impose a worldwide tariff. Good example. What is our understanding of Congress in 1977 vis-a-vis that Nixon example when Congress reenacts or enacts the regulate importation language into IEPA?
Congress at that time was fully aware that a Court of Appeals with exclusive jurisdiction had interpreted that very phrase very visibly, very prominently, to include the power to tariff, and then reenacted it without change. The court addressed a kind of lesser situation in Algonquin when it came to Section 122, and the court said President Nixon interpreted this to include a tariffing power, a tariffing-like power, and then Congress a few months later reenacted the language without change, and that's powerful evidence of congressional acquiescence. So that immediately historical background is very powerful, and it's buttressed, of course, by sources going back to the founding, where we say the phrase regulate importation, a quintessential application of that is the power to tariff. That's how you regulate.
Well, Algonquin, as you've mentioned many times, is obviously very important here for us to understand exactly what's going on in Algonquin. The phrase there is different, adjust imports, and they really, the other side, your friend on the other side, really relies on the difference in language. And I just want you to give your best answer to why regulate importation encompasses tariffs when we held that adjust imports would encompass monetary exactions.
Three answers, if I may.
Mm-hmm.
Adjust is narrower than regulate. And so, therefore, the writer includes less.
Follows.
Second answer, adjust is the second Black's Law Dictionary definition of regulate. The Black's Law Dictionary, our original plain meaning dictionary definition, says adjust by rule, mode, or rule, method, or established mode. So there's just a plain meaning link there. Regulate, adjust is a kind of regulation. And then I think far more importantly, regulate importation. I can't emphasize enough. Going back to the time of the founding has been understood that the manner in which you regulate importation, the natural way to do that is to tariff.
So as I understand your response to Justice Barrett in that last question, you're saying that the power to tariff fits naturally with the power to block and seize. That was your example. But I guess I'm trying to understand then your argument from the text of the actual statute, because the statute, unlike what you suggested to Justice Kagan, is focused on the actual actions that the president can take. In response to Justice Kagan, I understood you to say that Congress was giving the president broad authority to act, and it was within a particular domain, which is the domain of emergencies with respect to foreign power, but the president could basically do a lot of things. But when I read the statute, it is telling the president exactly what he can do: investigate, block during the pendency of an investigation, regulate, direct and compel, nullify, void, prevent, or prohibit. And I guess what is a little concerning to me is that your argument suggests that we should see the word imposed, the phrase imposed tariffs, in that same series of things that the president could do. We don't see that word, and instead you take regulate and say that must mean that. So I guess I'm getting back to Justice Barrett's maybe original question, which was, where else in the code has Congress used the word regulate to sub in for imposed tariffs?
TWIA. And then this Court's opinions, of course, have used regulate and import, or have pointed out that duties are the natural way to regulate foreign commerce.
But you're saying we should not have expected to see the same level of granularity with respect to the president's authority to impose tariffs as we see here: investigate, block, direct and compel, nullify, et cetera.
I think it would be very unusual for Congress to spell out all the ways that you can regulate in that statute.
So regulate becomes a big catch-all. The rest of the other things.
Well, I mean, we have a concession of that from the other side, that regulate at least includes qualitative methods, quantitative methods, quotas, licenses. They concede that regulate, there's a lot in regulate that's not spelled out there. And our point is, you don't need to spell out tariffs, because that's, like, of all of them, the most natural, the most quintessential method of regulating imports.
And yet, many presidents have not used regulate in this way to impose tariffs. I understand you point to President Nixon. We have licenses from Lincoln, but
As
no
I said
one
to
else.
Justice Kavanaugh, presidents who are faced with international crises to which tariffing is the natural response, that's President Nixon and President Trump, have invoked this authority. And also, frankly, President Trump invoked this authority in May of 2019 as well.
Can I ask you one question?
It's more historically attested than they can see.
Let me just ask one more question about the unusual threat. So in your conversation with Justice Gorsuch, that we had the climate change tariff hypo, and you indicated that there would be challengers to the notion that that was an unusual and extraordinary threat. And I'm just wondering, under your position, would they be able to make a legal challenge? Are you saying the court would not be able to review?
On that particular hypothetical, I think I said that'd be a question for Congress.
So not
I don't. In other words, that wouldn't be the sort of thing that courts would want to wade into. Is this really an emergency? That would not be probably very unlikely. That'd be a situation where at least there'd be very, very, very deferential judicial review of that kind of determination.
No, I'm asking you. Right, those are two different things. Is there no judicial review, or is there deferential?
Our frontline, Trump against Hawaii. Our frontline position is that it falls within Dalton against Specter. It's committed to the president's discretion when he makes his determination of a national emergency. But the court doesn't have to decide that because whatever review is very, very deferential. It's easily satisfied here.
Wouldn't your argument also apply to embargoes?
So, and this is the argument in the fine dissent below, and I think there are three answers to that, Justice Thomas. The first is revenue raising. Embargoes stop the shipment. Tariffs start the tax bill. They are first and foremost ways of regulating revenue. As some of your own opinions said, this is the way we actually chiefly got revenue for the first 100 years of our republic. Tariffs are constitutionally special because our founders feared revenue raising, unlike embargoes. There was no Boston embargo party, but there was certainly a Boston Tea Party. The second thing, textually, in the statute, it's different. Regulate appears in a cluster of verbs, as was said before: investigate, block, nullify, and the like. They describe embargo-like controls, prevent and prohibit, for example. But they don't describe revenue exactions. That's Justice Kagan's point. The one verb that's missing here is anything about raising revenue whatsoever. Another point, congressional displacement. Today, there is a whole host of statutes in the tariff architecture of Title 19, which both expressly confer the power to tariff and always impose clear limits. Embargoes by the president, embargoes don't have any of that. They don't set aside that whole thing. If you look at the Learning Resources brief at page 5, it goes through these statutes in detail. Section 122 expressly says duties and then limits it, 15%, 150 days. Section 201, any duty on the imported article, but it requires ITC findings. Section 301, impose duties. That's the language of the statute, but all sorts of procedural restrictions. Section 338, the same. I can go through this, and I could start, by the way, Justice Thomas, with the statutes at the founding, all of which expressly said the word tariff or an equivalent.
Let's go back to your non-delegation point. It would seem that if the tariff power cannot be delegated, your argument on non-delegation would also have to apply to embargoes and to quotas.
No, Your Honor, because I think tariffs, because they're uniquely revenue-raising, impose special, unique concerns that go back to our founding. And so I don't think that they apply to embargoes. And indeed, the history of this is very, very clear. That, as you just heard my friend say, in 1790, George Washington was delegated massive embargo power from the Congress. But what did Congress not do? And this is why the example cuts the other way. They never gave the president any sort of delegation of tariff authority at the time. Our point is not you can't delegate tariff authority. It's simply that you've got to do so with intelligible principles. And what you just heard my friend say is every single limit in IEPA is one that is not judicially enforceable. There's no limit whatsoever. And indeed, the main limit that was in there, he calls this some compromise position. The only compromise in 1977 was the legislative veto. And as this case comes to the court, that's no longer in the statute at all.
Counsel, yes, sure, the tariffs are a tax, and that's a core power of Congress. But they're a foreign-facing tax, right? And that foreign affairs is a core power of the executive. And I don't think you can dismiss the consequences. I mean, we didn't stay this case, and one thing is quite clear is that the foreign-facing tariffs have in several situations.
Right, and we are.
I'm sorry.
Oh, sorry. I'm sorry.
Were quite effective in achieving a particular objective. So I don't think you can just separate it when you say, well, this is a tax, Congress's power. It implicates very directly the president's foreign affairs power.
Yeah. Mr. Chief Justice, we don't disagree with a large part of that. We think instead of thinking about foreign versus domestic, the better way of thinking about it is Article 1 versus Article 2. And as my friend finally conceded to Justice Gorsuch, there is no Article 2 power here, at least when we're talking about peacetime.
Well, you don't agree with a large part. What's the little part that you do disagree with?
We agree with the idea that tariffs have foreign policy implications. Absolutely. Our founders recognize that. That's in the Federalist Papers. But nonetheless, they exclusively committed that power to the Congress in Article 1, Section 8 and gave it as its first power. So when you hear my friends cite cases like Egan and Garamendi, they just don't apply to this specific unique situation in which Congress has given that power. And if you were tempted by this, I think the best place to look is Youngstown, because what Justice Jackson said, and I was surprised that he quoted pages 652, because what Justice Jackson said is, quote, emergency powers tend to kindle emergencies, so it's essential the public may know the extent and limitations of the powers that can be asserted, and persons affected may be informed from the statute of its rights and duties. And Justice Jackson went on to say there that it's notable our founders didn't give the president revenue-raising power even in a time of war.
Can I just get a clarification of your answer, which is you agree if the word tariff were in the statute, that would be acceptable and constitutionally permissible, correct?
No, it would be it'd be constitutionally permissible. The question would then be, is the open-ended assertion of power here? Because every other
I get as applied to this case, but the general point is, yes, Congress, you said it's assigned to Congress, but Congress can grant authority to presidents to impose tariffs.
Absolutely.
As a general proposition.
Absolutely.
Okay, so we have to figure out then what regulate importation means. And you've heard my questions. If this statute came out of nowhere in 1977, I think your case would be, obviously stronger. We have to figure out, at least I want to figure out, what the Nixon precedent stands for and what Algonquin stands for. On the Nixon precedent, the question is, I think, was Congress aware of that, meaning that when they used regulate importation and it's now being used to encompass tariffs, that's not unheralded because Congress was well aware. You know, President Nixon announced those tariffs in a nationwide primetime speech, 10% across the board in August 1971. It was not some kind of little piece of paper. So it was well known. The question then is, was Congress, why didn't they change the language? Why didn't they say regulate but not tariffs? That's kind of the difficult question from the Nixon precedent that I'll give you an opportunity to answer.
Thank you, Justice Kavanaugh. So 5 answers on the Nixon precedent. First, there is no evidence that Congress thought it was ratifying Yoshida. It was a single court of appeals case.
Let's start with just the bare statutory language. You have arguments about structure. You have arguments about history. There are strong arguments, but let's just start with the bare statutory language, regulate importation. If we disregard all of the rest, would you dispute that that would include the imposition of a fee?
So if it's revenue, yeah, we do dispute that, absolutely.
What if there were a statute that said, I mean, suppose that there's a particular national park that's very crowded, and Congress passes a statute that says the National Park Service may regulate admission to the park. Would you say, well, that does not allow them to impose a fee?
So, Your Honor, sometimes we think of fees as not revenue raising, but rather capturing the cost of government services. In your example, the going to the park, that may, those kinds of cases, which I think.
Suppose it goes beyond the cost of running the park. Congress just wants to control admission to the park, regulate admission. Wouldn't that include the imposition of a fee?
So if it doesn't raise revenue, then, and it's not about that, then I think that's fine. If it does,
it raises revenue. Then
I think it's a tougher
the hypothetical. That wouldn't apply.
So I think in that circumstance that it wouldn't be a regulation in context. It wouldn't be permitted. That is, at least in the context of tariffs and trade, we know, Justice Alito.
Okay, well, that gets into your other arguments. We start out with the bare statutory language, and that was what my question was about. Do you think all tariffs are revenue-raising? Suppose that instead of imposing these across-the-board tariffs, suppose that an executive order imposed a tariff on one particular country and provided that this would take effect in 90 days. And suppose that within those 90 days, an agreement is reached with that country so that no tariff is ever collected. Would that be a revenue-raising tariff?
I take it the initial point and on its face it is revenue-raising, that's what it's for, and so I think that would.
What if the relevant universe is tariffs that are imposed in emergency situations?
Yes. So I think it cuts the other way. So, as Justice Jackson said, it's when you're in an emergency situation, the statutes actually have to speak with more precision. The public needs to know because emergencies beget emergencies. And I would say the best way of understanding what Congress does in emergencies is to look at their emergency statutes. Not one has ever given the president a taxation power or a tariff power. We've had all sorts of emergencies for 238 years. No president has ever said, the way to deal with that is I need to have a tariff authority.
It seems like you're putting a major questions thumb or an interpretive lens thumb on the plain text there. Is that fair?
I think you could call it major questions. I just think it's like Justice Barrett said in Nebraska versus Biden, the most natural way of understanding what the statute is about. We're talking about, under the government's reading, a statute that gives the power to the president to junk the entire tariff.
I understand that, but you're not disputing licenses or otherwise means what it says. You're saying that we should interpret that narrowly for particular reasons.
So I think I am disputing it as well. I think the licenses, and this is something Justice Sotomayor was saying, don't expand the power. They are not verbs. And so it is limited to the 9 verbs there.
I found it interesting to hear you make the non-delegation argument, Mr. Katyal. I wonder if you ever thought that your legacy as a constitutional advocate would be the man who revived the non-delegation argument.
Heck yes, Justice Alito. I think Justice Gorsuch nailed it on the head when saying that when you're dealing with a statute that is this open-ended, unlike anything we've ever seen, to give the president this kind of power, yes, this isn't just delegation running riot. This is delegation that's a legislative application.
Wouldn't you agree that statutes that confer on the president real emergency powers are often phrased much more broadly than other statutes? Isn't it the very nature of an emergency? I know you dispute the fact that this is a real emergency. Maybe it's not. But isn't it the very nature of an emergency provision that is going to be more open-ended?
So, Justice Alito, we think it actually cuts the other way. As I was saying earlier, that's what Justice Jackson said. And, you already confronted that in Dames and Moore and said it's not that open-ended, even though it's an emergency.
Just on the Nixon point, because you said, I think, that the current tariffs are unprecedented. I mean, that was a 10% worldwide tax on every import into the United States, I believe. I mean, we don't need – I just think that's a fact. You have arguments about that. You made good arguments about that, but just wanted that point to be clear. On Algonquin, to pick up on Justice Sotomayor's kind assist, your argument here is that the statute has to use the word tariffs, I think, basically. And we went through Nixon and Yoshida, but then Algonquin, the statute for 232, does not use the word tariffs. It uses adjust imports. And President Ford had imposed, again, a pretty significant tariff on oil imports. It was challenged. It got to this court. The attorneys standing where you are stood up and said the license fee now before the court involves the broadest exercise of the tariff power in the history of the American Republic. In fact, we would have to go back to George III's stamp tax to determine as broad an executive power as claimed in this case. The statute is a simple one. It does not mention the tariff on its face. The argument there was the word tariff was not mentioned, used to adjust imports. The court, obviously 9-0, rejects that argument, in part because, as others have pointed out, the court does a lot of questioning. Well, what's the difference between a quota and a tariff? And what's the difference between an embargo and a tariff? And so when the court writes the opinion, it says we find no support in the language of the statute, the language, for respondents' contention that the authorization of the president to adjust imports should be read to encompass only quantitative methods, i.e. quotas, as opposed to monetary methods, i.e. license fees, of effecting such adjustments. So, on your basic point that you need the word tariff, Algonquin says you don't need the word tariff. And that was President Ford's oil imports. It's 9-0. The oral argument goes through this. Your answer.
There's a lot there, Justice Kavanaugh, so please bear with me. First, I'd like to clarify what our position is generally and then deal with Algonquin. Our position is not that you have to use the word tariff or any other magic word. It's true that Congress has used a specialized vocabulary since the founding, since 1790, using words like tariffs or duties. But as I was saying earlier to Justice Gorsuch, you could even use the word regulate, as our page 15 of our brief says. Or you could even imagine something that says, quote, the president may regulate importation by requiring importers to pay 10% of the value of goods to the Treasury. So I don't think you have to use any particular word. The question is in context.
Algonquin didn't have anything like that, but keep going.
So Algonquin does have, I think, a context that's miles apart from what the government is seeking here to do with IEPA. So first of all, it is a common-sense statute. I understand there's some rhetoric by common-sense reading of the statute. I know there's some rhetoric by the lawyer who stood here before, which is, of course, forgivable. But it was a statute about one product. 232 is article by article. It's one product. This is a billion products or even more that the government is seeking. The Algonquin was expressly a trade statute. It was the 1962 Trade Act. It's everything this case isn't. Algonquin had a specific reference to the word duties in a separate provision. Algonquin had a legislative history that was clear as day that the president was given this power. And I understand this court today doesn't look to the legislative history, but the way Algonquin got to where it was by saying the legislative history, the chief sponsor of the act.
I think I'll disagree with you on that. It does a plain text and then says, is there anything in the legislative history to defeat the plain text? So I disagree pretty strongly with you on that, but it doesn't defeat your point. Keep going.
Okay. So I'd also say maybe the most important point, 232, our argument is not just that you have to specifically authorize a tariff with some sort of word, but also that one way of understanding whether Congress is delegating its awesome tariff power, its awesome taxing power, is to ask, are there limits to what Congress has put in? And in Algonquin, in Section 232, the Court points to and goes painstakingly through all the limits. The first words of the decision are all about how constrained the statute is. It's a reticulated scheme. The cabinet secretaries have to make certain findings. There are specific statutory factors Congress says the president must look at before acting. There are public hearings. There are limited remedies, quote, to the extent necessary. All of that is in the statute. All of that is in the Algonquin opinion. None of it is in IEPA. That's the problem.
So you agree, I assume, given all the verbs on this list, that the president could do something like just shut down all trade between us and, say, China, right?
Yes. I mean, there are other limitations in the statute.
Okay. So doesn't it seem, and I think this is one of the points that Algonquin makes, and I think it's a point that Justice Kavanaugh was making, doesn't it seem then, I mean, I don't want to use the phrase lesser power, lesser included measure, but doesn't it seem like it would make sense then that Congress would want the president to use something that was less, weaker medicine than completely shutting down trade as leverage to try to get a foreign nation to do something?
And the president can in the form of, for example, quotas. But what makes an embargo or quotas fundamentally different from tariffs, as my friend has already explained, is the revenue-raising aspect of that. That makes it a far more significant power. It creates additional danger of overuse. And I think the other point, as Justice Jackson was pointing out, is that it cedes control over whether the transaction occurs from the government to the individuals engaging in this transaction. And that is not what IEPA is intended.
What makes something revenue-raising? I mean, fees raise money, and unless they're going to be kind of one-to-one, this is exactly what it costs. I mean, it might raise some surplus. It might raise some extra. So is it the purpose? If the purpose of the fee or the tariff is to raise money, is it the purpose that makes it revenue-raising, or is it just the fact of surplus created that goes to the Treasury? Like, how do we decide this?
Yes, I think it's the effect. And to be clear, I think there would be a serious difficulty with interpreting any of these words, even to allow revenue-neutral exactions here, because none of them involve — and again, as far as I'm aware, IEPA has never been used in that way. But I don't think —
Not even a processing fee?
I am not aware of any use of that sort of under IEPA. But even if that is permissible, I think that's permissible precisely because it doesn't have the effect of raising revenue.
But can't do a 1% tariff. That doesn't seem, but I want to get your answer, to have a lot of common sense behind it.
I think it absolutely does, because it's a fundamentally different power. It's not a donut hole. It's a different kind of pastry.
And on that power, that's a good one.
That's it for today's High Court Report episode. I hope you enjoyed. If you liked the content, please follow, rate, subscribe, and share. Talk to you soon.